Gain weight, lose your job? Well, that actually happened to some cocktail waitresses at the Borgata. That Atlantic City casino requires the waitresses called this is what they're called, I'm not opining here, the Borgata babes. They require them, no, Snooki, to be fit and thin. In fact, they have weigh-ins and they could get fired or suspended for putting on the pounds. Some of them sued, but an appeals court ruled against them. Its ruling said, and I'm going to read this in part, quote, the Borgata babe position, and again, this is the court's ruling, comprised more than a job serving drinks and washing glasses. From its inception, an element of performance and a public appearance component was part of the described Borgata babe position. And again, I'm reading verbatim here. We've seen this before, but I've seen this ruled in different ways. Like, why in this case, Jimmy, is it okay to say more than 7% body fat or whatever it was, hit the bricks?
Well, my understanding is that the ruling was predicated on the assertion that they do it for the men and the women. So, and of course that was challenged, and it's kind of ridiculous. I've been to the Borgata a couple of times, and I've never seen a man walk up and serve drinks with a mini skirt on and so on and so forth, or playing any role like that. But that was the basis for the ruling, that as long as they do it for the men and the women alike, it was okay.
It sure sounds like separate but unequal. You know, I mean,
but that's the thing, though. That's the thing.
Whether they did it to men and women, can you legally say it's the job? You know, I don't care if you packed on a couple and you had a bad time, you're out on the bricks.
Well, here's the interesting part about it, right? As an employer, you can impose any kind of bona fide occupational qualification that you want, so long as it's not based on an invidious or discriminatory motive. What's an invidious or discriminatory motive? Against a traditionally oppressed minority group. What would be interesting to me as the defendant, the plaintiff, if I was one of these women, suppose I have some sort of, I contract some sort of genetic disorder that requires me, that makes me gain weight against my will, and I'm ADA protected. It's a disability that I have. The interesting thing, maybe if they sued under a different theory, said, oh, this is some genetic problem that I have, I can't help it, and you're discriminating against me because I have a disability. Then maybe you get some traction on the suit. Just to claim that they can't fire somebody because weight is not a bona fide occupational qualification, that's a zero. You have to look sexy to do the job. So if
but can they do it without doing it with the men? I mean, well, I understand that was a component of it, and that was what that's kind of the hook of the ruling.
I don't understand the men, because the job is called Borgata babes. They're not Borgata boys. So it's going to be they're not going to be similarly situated for equal protection purposes. It's not a job for men. It's a job for women. And from what I gather from the Jersey Supreme Court's opinion, they had notice of the weight policy, and before they took the job, that you can't gain more than X amount of pounds.
But we have a lot of isms that you're not allowed to do: ageism, sexism, racism.
Right, but weightism isn't one of those.
But where's the line?
Categories.
If somebody decides to write it that you can't have more, I'll make up a number, than a 10% body fat. That's tough, but you know what? Okay.
It's coming because obesity
but what if they
is an
say
epidemic.
It's like
we know that.
3% that borders on the unhealthy.
Sickness.
Is there certain things that they can write whatever they want? It's still unenforceable. When does it become? Is there a line? As long as you write it, it's enforceable. If you agree to it when you sign on, or does it have to be fair?
I think if you're most employees in the United States, they have very few protections. They are not members of unions. They are employees at will. And if you sign a contract, quite often the contract benefits the employer. So for example, here, if they are contract employees and you know that there's a policy in terms of weight, you're signing on saying you understand that and that you're going to comport with that requirement. Now, I go back to what Mark said. I think that's a great analysis. If you look at the Americans with Disabilities Act, that's a different issue. Now you start to look at, well, okay, maybe I'm outside of the 7 pounds, but why? Did I contract an illness? Am I pregnant? Now at that point, you have different areas of the law that come into the analysis. It's a situation not unlike in sports, for instance. If you are no longer able to run a 4.5 40, you probably won't still be in the NFL.
But that's performance-based. this isn't necessarily performance-based. They can still clean the drinks. They can
We'll
still
go
serve
back to the
Yeah, but
Abercrombie case from the Supreme Court
Right.
that we talked about last year, right? The argument Abercrombie made was, we're an all-American brand. We don't want someone with the hijab here. It doesn't fit with our image. And the Supreme Court said, no, that's no good. That you have the right to that policy, but you can't discriminate on the basis of religion. Right now, I didn't read the papers in the lawsuit. The weight gain is obviously is going to be ruled as not a suspect classification, but we're told there's an obesity epidemic in this country, that eating is beyond people's control. It's a very small step to say this is beyond my control. I have an affliction, and you can't discriminate against me based on the affliction.
Well, it didn't work for him. They didn't
they
try
probably
that,
didn't
to our
argue.
knowledge, and it didn't work, and it's interesting where this goes from here.
Goes
But
nowhere.
what if they said you cannot have an appearance that's age-related? We're going for a
No
youth
good.
demo here.
Well, that
Well-
would be one of the classifications that they would run afoul of. But, you know, if you look at this
So
case,
my grandmother could be a Borgata babe?
maybe.
Well, it's appearance.
Made
if you
about
look at-
Lucy the elephant. She could be a Borgata
If you look at the
babe.
case is interesting to talk about because they're beautiful women that you're talking about.
Lucy's beautiful.
But if the requirement was that the guys have to stay in shape and go to the gym and they can't get flabby, and that's the way, and you said, well, you've stopped working out and you're obviously flabby, we can't have you be a whatever, pick your job description. The case, you'd kind of understand it better.
Right.
But when you look at this case, you're kind of mixing in, is it sexual discrimination? It has nothing to do with that, according to the court.
It's about the math. Yep.
That's right, man.
All right, coming up next, a sad story, but it raises a lot of questions. Boy kills himself that after his girlfriend encouraged him to do it. No one said the girl pulled the trigger or in any way directly led to his death, but nonetheless, the cops have text to prove here that at the very least, this was one callous young lady. We're going to hash out what is really a bizarre case.